Okay, good. All right. Well, thank you all for coming. Thank you for attending. We will, I've got actually several questions. There are more than usual this week, so we'll go through those and then we can answer any questions. Just to give everyone a heads up on where we are so far and kind of what's happened in the last week. As you probably saw in the press, there was an overwhelming acceptance. We're not sure of the exact numbers. Those will come out tomorrow, but we think it's around 90%. Our clients were a little over 98, and the overall amount is right around 90. So it looks like the vast majority of people accepted the plan. We've had a couple of hearings since then. There was one on Friday, and then there was one earlier today. There'll be another one tomorrow. I can take you through and just kind of give you the highlights. Last Friday, this was a kind of an interesting issue, and it dovetails in with some of the questions that were asked. But a lot of people wanted to know about the attorney fee issue because that was something that was outstanding. And specifically, the attorney fee issue relates to whether or not an individual is going to receive attorney fees as part of their award. In other words, out of that trust, the $13.5 billion, is the trustee going to do it the way that we've always done it in the past and the way that we assumed it would be done, which is where you have economic damages, attorney fees on those, and then on top of those, non-economic damages. So that was an issue that we felt strongly about, and it was resolved at the hearing last Friday. The attorneys for both sides agreed, so this is not going to be an issue, that as part of the award, the trustee must award all damages that are available under California law, including attorney fees. So that was not in the claims resolution procedures, but one of the attorneys was assigned by the judge to draft the language. We'll all look at that, we'll get it approved, and we'll put it in. So that does not look like it's going to be an issue. We have the confirmation hearing next Wednesday and Thursday. So if for some reason it does become an issue, we can certainly raise it then, but it looks like that's resolved, so that's a good issue, or that's a good result. So let me dive into these questions that we got, and the first one has to do with FEMA. And specifically the question is, why are we having to pay FEMA back any money when other disaster victims do not? Is it only because we filed the lawsuit that we are under this obligation? And the answer to that is twofold. Number one, we are 99.9% sure that FEMA is not going to get any money. The way that this is set up is that FEMA is subordinated to all of the individual claimants. So the only way they will get a penny is if after all of the money is paid out and after everyone is paid, there is money left over. Now, realistically, there is virtually no chance of that happening, because if for some reason the trustee did not pass out all of the $13.5 billion as part of the compensatory damages, there would still be punitive damages. And in some of the fires, most notably the Camp Fire, punitive damages were a virtual certainty. So when we made this deal with FEMA, we explained, look, you understand that by taking this subordination, number one, you have no right to get involved with how the trust passes out the money. And number two, you're virtually certain not to get anything. They said they understood that. So as a practical matter, it is a virtual certainty FEMA will not be paid a dime. That said, to answer the technical question, why is it that FEMA had a right to assert a claim? The answer is yes. It's because there was a third party that was responsible for causing the disaster that led to FEMA coming in. Obviously, with things like hurricanes, floods, there's no way you can sue anybody, as my dad used to say. You can't sue God, so really there's nothing there to do. And it's the same here. Ordinarily, when FEMA gets involved, there is no one that you can go after. Here, because PG&E was responsible. Technically, FEMA had a claim, and that's why they asserted it. So that's the answer to that. The next question is, how can we add things to our claim we forgot to include on lists that we made for insurance, FEMA, or lists that you've already given to us? The answer to that is simple. If you want to add anything, please just let us know. Pretty much every day, I will receive new lists from people. They'll say, you know what, I forgot to add this, I forgot to add that, and you are always free to update your list. If you'd like, you can send them to me. The best person to send them to is one of my assistants, Carla Mayer. Her number or her email is Carla, K-A-R-L-A, @slffirm.com. You can also send them to info@slffirm.com. But anytime you have any questions or you're not sure, just go ahead and send them to me at gerald@slffirm.com, and I'll make sure they get to the appropriate team members. The next question is, do you know if the settlement amount is exempted from tax, from being taxed because it is not earned income but a reimbursement? That's a good question. Now, I have to preface this by saying I am not an expert on tax law. So I can give you the very basic outlines, but I can't give you any specific advice to your case. What I can say is, if you have any questions about it, you should consult with a CPA, tax attorney, or other qualified professional. And we can certainly recommend individuals who specialize in this area of law if anyone is interested. We have a CPA that we've worked with in the past whose specialty is dealing with these types of situations. That is, where there's a disaster, there's a tort suit, and then someone receives a recovery. We're happy to give you his name. You can talk to your CPA, but professionals can answer those questions. Here's kind of the general rule. The question here was exactly right. If you recover something and it's a reimbursement as opposed to a payment of some kind, then it's not income. The problem is it can get pretty dicey. For example, if you receive recovery for lost wages, then that clearly is going to be something that's taxable because you're being compensated for lost wages. On the other hand, if you were to receive money for damage to real property, damage to personal property, and you then spent the money to repair or replace that property, now you're talking about reimbursement, so there's no taxable event. So the general rule is that when you recover money for damage to real or personal property, and you actually do spend the money either in repairing that or replacing it, whether it's buying more real property, whether it's buying more personal property, or using the money to actually repair the real or personal property, then typically there's no taxable event. Now, obviously, if you were to take a capital loss, for example, during the year that the fire occurred, and then you were to receive money for that damage, now you would have a capital gain, so you would have to pay. So again, it can get technical, so I strongly encourage people to talk with a qualified professional about this. Next question is, could you explain the difference between what insurance says it will cost to rebuild a dwelling and what your experts determine it will cost, and how that will be figured out? The specific question here is, we won't know the final amount AAA will give us until we finish rebuilding, which may be next year. I understand that amount will be deducted from our settlement. How will that work if we are ready to submit right now? It's a very good question. So the answer is basically this. When you have a standard policy, there are going to be policy limits that apply. And so what the trustee is going to do is to look at what those limits are. And ordinarily, that is going to be the amount that is going to be deducted. So to answer this person's question, if their policy limits were $500,000 to rebuild their home, then that's what ordinarily would be deducted. Now, if you do not spend the full amount, but you still claim that you should recover something from the trust, you can make an application and ask that the trustee waive that requirement. But ordinarily, that's not the case. And the reason for that is because insurance companies really make their living on not paying claims, we didn't want to give them an incentive to not pay claims and to have people instead go to the Fire Victims Trust. As I'm sure you know, the insurance companies had paid and reserved amounts of $19.5 billion. However, they only spent a little less than $16.5 billion, which means that as of right now, there are $3 billion in reserves that the insurance companies have determined they're going to have to pay. The absolute last thing we want is for the individuals not to recover every penny of that $3 billion, because the more they recover from insurance, the more is available out of the $13 billion fund that is going to be used to pay everyone's claims. So that's why the insurance offset was set up that way, to look at the policy limits. Now, again, it's not going to work in every case, and on individual cases, we can say, Your Honor, it wouldn't be fair to do it, here's why, and the trustee can waive that. But that's the general answer. Now, if for some reason you have a unique policy, and these are very unusual, where you have actual amount, actual cost to rebuild. Most say actual cost to rebuild, but then put a cap on it. However, there are a few policies, most of which were written in the 90s and simply were never changed, which have actual cost to rebuild, but with no cap. If you have one of those, then you are going to have to wait until it's done. Although again, if you had the actual cost to rebuild, it's unlikely that you're not going to recover the full amount from insurance and that you're going to have anything left over in that category. So what I would say to anybody who has specific questions is either call or email me and we can talk about the specifics of your case. But the way it's generally going to work is that the trustee is going to look at what the total amount of your policy limits are. They're going to subtract that from the total amount of damage, and then they're going to pay you the difference. Next question is, will the figures your experts determine, that is, that the experts put in their reports, be reduced during the claims resolution procedures? The answer is it depends. In most cases, yes. The reason for that is that the experts that we hire are just that. They're our experts. They are paid by us to present the facts in the light most favorable to our client. If they didn't do that, then, frankly, we wouldn't hire them. It's not that they lie or that they misconstrue anything, but you can get two equally qualified experts, both of whom have integrity, one hired by the defense and one hired by the plaintiff, who are going to come up with different reports. Now, they're not going to be dramatically different, but in any kind of analysis, there are always judgment calls that have to be made by the expert. And our experts are going to make those judgment calls in your favor. And at the same time, defense experts are going to make them in the defendant's favor. So the mediators that we've selected who are going to be looking at this, the claims administrators, the trustee, they've all handled a number of these cases. So they've seen how when plaintiffs come in, their reports are often, a bit on the high side, just like when defendants come in, they're a bit on the low side. So while I can't say that they're going to reduce them in every case, and I don't think they are, I do think in the majority of the cases, they're likely going to look at it, going to look at all of the factors that are involved and probably reduce them somewhat. Now, obviously, if they reduce them more than you believe is reasonable, then we can appeal and we can ask for more money. So that's my best guess without having any definitive answer on that. Okay, next question is, once the claims resolution procedures are finalized, will they be available for public review? Yes, they will. They'll be online. We will have them on our website, and if you want a copy, we're happy to send it to you. Just let us know. Right now, it looks like July 1st is the date that the claims resolution procedures are going to be done. We're certainly working to make that the deadline and the date that they are produced. I think that might be a little bit optimistic. I think we might be looking at a couple weeks later, but as long as we can get them done in July, that will be great. That way they will have some time to review and to get cases ready for the August 29th funding date. The last question in the submitted questions is, how do I provide receipts for our time, the time of friends and family, for the energy to work and to clean up the property? The answer is you don't need receipts for that. We just need to know how much time you've spent on it. Typically, we just ask people to give us an estimate and we put that in. There's conflicting case law on whether or not it's compensable. It is definitely not compensable at the individual's rate. For example, if you are a surgeon who charges $300 an hour, you are not going to be able to recover $300 an hour for cleaning up your property. You can make a claim that you should be paid the prevailing wage for that work. So if the prevailing wage is $20 an hour, you can make that claim. But if you're someone who has a high hourly rate, you're not going to be able to recover that hourly rate. You're going to be able to recover the hourly rate that is typically associated, the standard in the industry for that task. I encourage all of our clients to put in how much time they spent. And the reason for that is, well, again, the case law is conflicting, and basically it's up to the arbitrator or the trier of fact to determine if they want to do it. If nothing else, it demonstrates what you went through and the annoyance and disturbance. So, you know, if you've spent 1,000 hours either cleaning up your property or dealing with insurance or doing all of the things that you've had to do because of this fire that was no fault of your own and that was caused by PG&E, you should put that in. Because even if they don't consider it as part of an economic loss, they can look at it and say, look what this person had to go through, and factor it in for the non-economic losses. So those are the questions that we received in advance. Next week is going to be it's called a trial, but it's really more of a hearing, and it's essentially the plan approval hearing. So what's going to happen is the bankruptcy judge, Judge Montale, will go through and he'll hear every objection that is made to the plan. Now, some of these will be made by the handful of folks who voted against the plan, and they're going to say the same things they've said before, that they don't think it's fair, et cetera, and they have every right to do that, but no one thinks that's going to really go anywhere. You know, basically the bottom line is the plan is lawful, and it was overwhelmingly approved by the fire victims. So other people saying we wish it would have been different isn't going to do anything. However, there are some very key issues that are going to be decided, and here's where we're going to be involved, and that's going to be things like the restriction of rights agreement. I know this has been talked about a lot in the press, but one of the things we still don't have that we need is this restriction of rights agreement. So PG&E is going to go in and is going to be saying that it should be X. And specifically what they're saying, we won't know yet. They'll file that tomorrow. What we're going to say is that the restriction of rights, and this relates to when individuals can sell their stock, should be the exact same for the trust as it is for all of the institutional investors, all of the hedge funds, the backstop parties, everyone. Everyone should have the same deal, and no one should be able to sell in any different quantities or any earlier than anyone else. We'll see what Judge Montale does, but that is certainly an important issue that we're going to, in all likelihood, we may be able to get it done in the next few days, but my guess is he's going to resolve it. There's a couple of other technical issues that have to do with the claims that are being assigned to the trust. This was something we've talked about before, but as you know, in addition to the $13.5 billion, half in cash, half in stock, there is also the matter of the claims against the third-party contractors that PG&E has. And these would be the tree trimmers, people that were supposed to inspect, perform maintenance on the lines, things like that. We believe the value of those claims is going to be somewhere between 500 million and $1 billion, possibly as high as 1.2 billion. So those are very key. And we were not happy with the language that was used in the plan to assign those over. We believe the language should be a little bit different. These are technical issues, but these are things we're going to be fighting over. because we don't want there to be any issue that those funds belong to you, should go into the trust, and we don't want PG&E to be able to come back 6 months later after they get out of bankruptcy and say, no, wait a minute, we reserved that claim. So those are the types of issues. They're not going to be particularly, for lack of a better term, sexy. They're not really, high profile, interesting issues. They're more nuts and bolts that relate to the specifics of the plan and how it's going to operate. So that's what we're going to focus on Wednesday and Thursday. It may go over into Friday. And as soon as we have any news on that, we'll let you know. I do want to have another town hall next Thursday, so we can bring you up to speed on where we are in the claims or in the plan confirmation trial. And then we can answer any questions that have come up at that point. So that's all that I have. I'd like to open it up, and anyone who has any questions, let's go ahead and take them.
Hey, Jared, I have a submission here that says, what if a claimant receives a settlement amount to rebuild and he does not rebuild in the near or distant future?
In terms of the requirement that you rebuild, there really isn't one. Obviously, you have to answer truthfully when asked if you intend to rebuild or if you'd like to rebuild. But if you receive the money and you decide, for example, that economically speaking, it makes more sense for you to sell your property, then you have every right to do so. There are no specific performance requirements. In other words, they're not going to give you, for example, if it was going to be $500,000 for you to rebuild, they're not going to give you the $500,000 and say, however, if you don't rebuild within X period of time, you have to return it. The settlements are, and the awards, once they're paid out, are final, and they can't ask for the money back if you elect not to rebuild.
I don't have any more submissions here via the chat. And for those of you watching us, you can unmute yourself if you have a question.
I have a question. We're in a situation where we did purchase a house out of the area because we just needed a place to live and couldn't find rent, and we're older, but we still want to rebuild. What's our situation with our insurance company or with PG&E or you guys at that point, that if we do want to rebuild, but we just, haven't done it yet?
No, and that's not a problem at all. We actually, it's not unusual for people to end up purchasing homes, particularly when the rental market is as bad as it was after, for example, the Tubbs fire. The Camp Fire was obviously, we'd never seen anything like that, with virtually an entire town destroyed. But even, fires that don't destroy as much of a town, like the Tubbs fire, the rental market was incredibly tight. It was very difficult to find a rental property, and those that were available were overpriced. So what a number of our clients did, and a number of other people that we don't represent did, was just to buy a home. And the idea was they could then use their ALE to pay at least a portion of that mortgage off, and then they would rent it out and have a rental property once they rebuilt. So the simple fact that you've purchased another home does not make you ineligible to ask for the cost of cure to rebuild your own.
Okay.
Good.
All right. Do we have any other questions?
I do.
Yes.
I see. Yeah, go ahead.
My wife is 82 and I'm 86. Are they going to give any preference to older people? And when do you think we'll exactly know what the settlement will be? And I assume you will discuss that with us before you put it up to PG&E. Is this about right?
Yes. So let me take those questions one at a time. In terms of how they do it, technically it's going to be on a first come, first serve. What we do internally is we put people that we call preference to the front of the line. And preference is a technical term as it's used here. It refers to a specific statute. It's California Code of Civil Procedure, Section 36, subsection A. And what it says is that individuals who are 70 years of age or older and who have significant health conditions are entitled to preferential trial setting, and they have to have their case tried within 120 days. So what we do, just to make it fair, is anytime we have someone who we believe would qualify for preference, we put them to the front of the line of the settlement group, and that way they have the best chance of getting their case resolved before, in the event that something unfortunate were to happen. So all you need to do is just let us know, and we'll take a look, and assuming you meet the criteria, we will put you to the front of the line. Now, in terms of when we will know what the settlements are, the goal is to have the funding take place on August 29th or earlier. We've heard, this month they're feeling pretty good. The stock market's doing well, so they're saying, we'll get you guys paid in June. I don't want anybody to take that to the bank, because that's not binding. That's just what PG&E was telling us. But obviously that would be great. But I'm just thinking August 29th is when they're here. What we want to have happen is to have a number of claims worked up, so already submitted and worked up, so that payments can be issued as soon as they fund. So the way that we would do it is the claims that go in first will obviously be resolved first, and the hope is they'll be ready for payment as soon as that August 29 hits. It'll obviously take some time to get the checks cut, sent out and everything, but we'd like to see payments made hopefully by the end of September for the people that are resolved first. In terms of the amounts, it's not clear yet, because of the claims resolution procedures, if they are going to ask us to submit a final amount, or if they're just going to ask us to submit the individual breakdowns. And what they're talking about doing now is having questionnaires for each category. We would fill those out, provide the documentation, and then submit them, and then we would submit a narrative along with that. So certainly if we have to submit a number and you'd like us to run that by you, we're happy to do so. Just let us know. Otherwise, what we typically do is just submit based upon the documentation we have, and then we'll get a written response back setting forth what they believe the award should be.
Hello.
Yeah.
Yes.
One more question.
Sure.
On the contents list,
Mhm.
I was reimbursed a certain amount, and my contents list was about 40,000 more, except
Asking a question.
we've been married for 56 years then. And there's a lot of stuff that all you can do is guess the value.
Right.
I put that down. I lost 100 years of photos, personal photos, stuff like that, stuff I'd given my wife over the period of years. And I just made a statement on the contents list, and I don't know how they're going to handle it.
It's a good point. Those are two separate issues. So let me address the first one, and then we'll go to the second one. In terms of the amount that's over, the 40,000, that's obviously what we'd be trying to get from the trust, because you've already been compensated for the other. But you raise a very good point. You're talking about sentimental items, or what we refer to as cherished possessions. And those are just what you described, 100 years worth of photographs, something that you gave your wife that has sentimental value. In other words, the things that may not have a significant fair market value, but are very important to you. For those things, we don't list values. What we do is we list them out, and we ask that people be compensated for those in a non-economic value, because the non-economic value is going to be higher. And so that's how we've traditionally done that.
Yeah, I've got probably 3,000 or 4,000 slides of our family since we got married. I've got DVDs that are made up and stuff like that, letters.
Right. Exactly. That's perfect. And what we need you to do is
Yeah.
just give us a list that sets forth the significant items in that category that you lost, and then that's what we'll submit.
I don't know if I can give you a list.
Well, just usually what I tell people is
Give you a
try to
general list.
pick the most important.
Yeah.
So, you know, the photographs, that kind of thing. And you can just say, you know, I lost 100 years of photographs. I lost all of these different things that I had, and just pick out the ones that really stick out in your mind.
Okay, thank you very much. I'm very impressed with your firm.
Well, thank you very much, sir. I think Mr. Is it Stotterman?
Yes,
Please, go ahead.
I would like to know how the stock value of PG&E, which apparently is going to be about 50% of what we receive, how is that going to be paid out in the first round of payouts? And I also am wondering how the whole pay structure is going to work. As far as I know, from what I've been told, everyone has to have an agreed upon settlement before anybody gets a single nickel out of this.
Okay, good questions. Let's start with the stock issue. So in terms of stock, what's going to happen on what's referred to as the effective date, which is the date of payment, is that PG&E is going to deposit $5.4 billion in cash and then 6.75 roughly in stock. The reason I say roughly is that the value of the stock is going to be based upon a multiplier of the anticipated earnings for 2021. Right now, those anticipated earnings are $2 billion, $20 million. If you multiply that by 14.9, which is the agreed upon multiplier, and then you take the percentage that the trust is going to get of the company, which right now is a minimum of 22.4, that comes out to 6.75 billion. Now, we could get more of the company, or the earnings could be higher. If either of those two things happen, then we'll get more than 6.75 billion, but in all likelihood, it'll be right around there. It might be slightly less, might be slightly more, but that's the belief, that it'll be 6.75 billion. So all of that is put into the trust. Now, initially, the trustee will use the 5.4 billion in cash to pay out the claims as they come. At some point, the trustee is obviously going to need more cash, and at that point, in consultation with the investment banking firm that he has hired, which is Houlihan, which is a major investment banking firm, they will advise him and they will sell off stock as it's prudent. So, you know, they may sell off $1 billion in January, $1 billion in February. We don't know the exact amounts. That's going to be up to the trustee and his financial advisors, but they will sell that stock off as needed to pay claims. And that brings me to your second point. Claims will be paid out as we go. So you don't need to worry that every claim needs to be what we call liquidated, meaning that it has a specific number assigned to it before any claim is paid. The way they're going to address that issue, because you raise a very good point, which is what happens if there's not enough to pay everyone 100 cents on the dollar of their liquidated claims? Does that mean, as just happened with the loans to businesses, that the people at the front of the line get 100 cents on the dollar and the people at the back of the line don't? And the answer to that is no. The way the trustee is accounting for that is, let's say that your claim is adjudicated, you're the first one, and it's $1 million. That's what he decides the liquidated value is. He's going to pay a percentage of that claim now, probably around 75 to 80%, and then the remaining 20 to 25% will be held back just as you described. So they'll hold that 20 to 25% back, or whatever it is. Maybe it's going to be 15. They'll hold that back in the trust until they determine that they can pay everyone 100 cents on the dollar for their liquidated claim. That is their final amount. Once they make that determination, then they will pay you the balance of the 20 to 25%. If they decide as they go along that it's not going to be possible to pay everyone 100 cents on the dollar of their liquidated claim, and they can only pay 95, then they'll do that on a pro rata basis. So whether you're first or last, you'll still receive the same percentage of your liquidated claim, which brings up another point, because this is something that understandably a lot of people have asked. Well, what does that mean for attorney fees? If I only get 75%, does that mean that you get your third?
So goddamn sad. Ashamed.
All right, sure. Beats anything I've ever seen. In my life. What's the matter with you? Hey, sorry, I'm ready. I can't think of cable on there. There's another challenge. And the other here is my right. I do deserve a good dressing down.
Sorry, Jared. One sec. We have a little technical issue. You got cut off the last maybe 10, 15 seconds.
Can you tell me the last thing you heard?
You were starting to discuss the issue of the attorney's fees.
Oh, sure. Okay.
Asking about the percentage.
Right. So that's important, because one thing that people have brought up, which is a completely legitimate question, is, well, wait a minute. If I only get 75% at the beginning, does that mean that you get 33% of the total and I'm only left with the balance, which is about 40%? The answer to that is no. We only get paid based upon what you recover. So if you only get 75% of your final claim amount at the beginning, then we would get a third of that amount, not a third of the 100 cents. And that way, if there is a reduction, there's also a reduction in attorney fees.
I have another question.
Please.
You've proffered the idea that the first time through this, it might be 75%. How do we know what that percentage is going to be?
That's a question that the trustee will have to decide, and it'll be part of the claims resolution procedures. So one of the things we're doing right now is that we're gathering information, and we have weekly meetings where we give this information to the financial analysts, and they're trying to come up with budgets so they have a good idea of what that holdback is going to have to be. We have pretty good information right now, but there are a significant number of claims, there's about 15%, that we have no information on at all. And so what we're trying to do is get as much information as we can and come up with that budget so the trustee has an idea of how much he needs to hold back. Obviously, he wants to get as much money in your hands as quickly as he can, but at the same time, he has to be careful. So I think he's going to probably err on the side of withholding a little bit more than he believes may be necessary, just to make sure that if the claims come in higher than he thinks, he's not going to be in a situation where people that were resolved first got more than people that were resolved at the end.
Okay, I understand. This is probably the most difficult question you're going to get tonight. I'm a victim of the Butte fire, specifically in Anyway, we've been waiting 3 years. We were close to being settled, and then the bankruptcy happened.
Right.
What's the priority here in terms of handling who goes first? Even if it is 75%, getting it first would certainly help, especially given the conditions in this country right now. Thank you.
Yeah, very good question. So here's how it's going to work. It is officially first come, first serve. Now, the reason that means that the Butte people will generally, not in every case, but generally be toward the front of the line is that we've already worked up your case. Most of the Butte cases had been submitted to the mediation protocol. I think there were only a handful that hadn't. So they were completely worked up. So when it comes to a Butte case, we've been ready for the last 18 months. It's not like, for example, a Camp case, which was more recent. Some of the insurance files aren't closed. We still don't have the final numbers, that kind of thing. With the Butte cases, we've known for a long time what our mediation numbers were. We had all the reports and we were ready to submit. So once the claims process is open, the first cases that are going to be submitted are the preference cases. And those are for the individuals who are elderly and in poor health. But that's going to be a very small percentage of the overall. I mean, typically it's 1, maybe 2%. There just aren't that many, fortunately. There obviously are elderly people, but it's not just being elderly, it's also being elderly and in poor health. So those people are our priority. They go in first. As soon as that, generally about 1% goes in, then we're going to submit them as they're ready. The Butte cases are already ready, so they will go right in. And then obviously, if there's other cases from other fires that are ready, they'll go in as well. But we tend to put them in the order in which they were done. So that means that the Butte cases, and there aren't a ton of them, but there still are some, are going to be toward the front of the line because they're already ready, they're already worked up, and they're ready to go.
Thank you very much. I'm done. Let someone else speak.
Certainly. All right, Chewy, who's next?
I do have some submissions here. One of them is the only amount that your law firm takes of my final settlement, is it 1/3 of the gross amount?
The fee is 1/3 of the gross amount. There are also costs that depend, the costs of litigation, and those range. If you're, for example, a renter and you don't need any damages experts, then the costs are going to be very, very low. For homeowners, particularly homeowners with large agricultural properties, large tree acreages, they can be a little bit higher, but typically the costs aren't that high. So they will be some amount, but they're, like I said, they're generally very low.
Okay, I have a second submission here. It says in previous town halls, you said that without an inventory list or a personal property list, that a calculation of 60% over what was paid by insurance for personal property will be what the claim will be for the suit, for this suit. Does this hold true?
Yeah, that is a really good question. What we had talked about, and this was actually my committee when we did our different breakouts, and we tried to come up with ways to speed the processing of these claims along. And what our committee came up with was a recommendation that the trustee pay 60% of the cost to rebuild for personal property. I don't think they're going to do that. I think they're going to come up with a different number, but I think the 60% of the cost to rebuild, when they ran the numbers, they decided that was too high. So what I think they'll do is they'll have a lower amount, and then obviously if you want to submit a list to get more, you can do that. What that amount is, they haven't told us yet. Again, our recommendation was 60%, but eventually they'll come up with that. That'll be part of the claims resolution procedures. And then we can look at it and go over it with you and let you know what you would receive out of that.
Okay, and a recent submission here is, can you give us more detail about how payments will be received?
Yeah, let me make sure I understand. I think what the question is how do you receive a payment in terms of logistically, how do you get it? If that's not the question, then please send it in and I'll answer what your actual question was. If that's the question, then typically here's how it works. What will usually happen is that the managing agent of the trustee, and that will be a major bank, they're interviewing the 5 top financial firms in the country, so JP Morgan, US Bank, Wells Fargo, those types, so that there's no chance they can go bankrupt. They will be in charge of holding the assets, the 13.5, and then making the actual payments. And so what they usually do is they will wire the amount to the attorney trust account. And the trust account is a special account that we set up. It's done through the state bar, and it ensures that interest does not go to the attorney. It goes to the state bar for funding of indigent, I think it's indigent, I want to say access to the courts, but there's a specific program that it does. The key is to know that anytime money comes into the trust account, there's no way we make any profit off of it. By law, it goes to the state bar. So what'll happen is they'll send that in to us. Once we get it, we will give you a breakdown of what the total amount is, what the fees are, what the costs are, and then the amount that you will receive. You look at that and it's all in writing. If you agree with it, then you sign that, you give it back to us, and you let us know, again in writing, just so there's no misunderstanding, how you'd like to receive your money. Would you like it wired to an account? Would you like one check? Would you like several checks? Sometimes if there are family members, people like it done that way. It's completely up to you. As long as we get the instructions in writing, we can do it that way. And then that's how it works. So it's generally a pretty simple process, and it usually does not take very long. Sometimes there are unusual issues. People have unusual requests. And again, I mean, as long as it's not illegal, we will comply with whatever request you want in terms of how you would like to receive the money.
I don't have any more submissions here, Jer.
So this is Sharon. I have a question.
Sure.
One of your responses prompted a question. You know, a lot of us have gone to the work of putting together an inventory of our losses.
Mm-hmm.
And maybe this, I don't know if this sounds funny or not, but you know, if let's use the gentleman that spoke earlier, that he had lost $40,000, but when the cost to rebuild may be substantially, you know, could be a substantial figure, and if the claims resolution says, let's say they'll pay 50% of the rebuild cost, but his cost is only $40,000. Would you put in for the 50%, or would you put in the $40,000 that he lost?
Well, let me just make sure, just so we're all on the same page. I think the scenario that he was describing was that his losses were $40,000 over insurance. Remember, if we do use that 50 or 60% number, you're going to receive that minus whatever you received in insurance. So the actual amount you receive is going to be much lower. But our job is to maximize your individual claims. So one of the reasons that I encourage everyone to make a list, even if it turns out that the most advantageous thing for you is to just put it in and say, we'd like the percentage, is because we as your attorneys don't know what your actual losses are and can't advise you as to whether or not you're better off going the prove it up route, meaning that you submit your list, or if you're better going the just flat rate amount, unless we know exactly what you've lost.
So great, that answered my question. Thank you very much.
Sure thing. Shui, do we have any other questions that have been submitted online?
I have a few, but I have Brian Mills that has a question. Let me see if I can unmute him.
Okay.
Yes, I do have a quick question, actually. When we talk about the insurance list portion of it, it was said that we would need to substantiate. Is that a hard and fast rule, or is that just an additional helping hand when it comes to determining the amount to pay out for personal property? So in other words, if I can't
Right.
drum up a picture of every item, or obviously I'm not going to have receipts for them because those all went
Sure.
up with the items. What is there a hard and fast rule when we do the itemized list that we have to substantiate? Is there like a threshold amount, like anything over $2,000 you have to have a picture for, anything of that nature?
No, absolutely not. What we would like you to do is just give us the list. Obviously, for big ticket items, it's certainly helpful. You know, if you have a TV that's, you know, $1,000, $1,500, $2,000, you know, things that are not unusual, it's not going to be a problem. If you had a rare vehicle, for example, that was worth, 30, 40, 50,000. That's the kind of thing that, people would expect there to be some picture of. Even if yours were burned, typically you'll have a friend, a family member, somebody who will have a picture. Now, that's not always the case. There are times when you have a big ticket item that you simply can't prove up. And when that happens, we deal with it. But typically, what you want to do is just put yourself in the position of the claims adjuster. And you want to try to make their job as easy as possible. Help them help you, give you money. They want to give you money. They just want to make sure that they don't pay out on any fraudulent claims. So the more pictures, the more anything you can get that documents it, the better. But there really is no rule. Just do the best you can. If you have any unusual issues that come up, for example, you have a larger ticket item that you just can't provide anything that documents it, let us know and we'll work on it. A lot of times you can, for example, if you had a collectible car or something, and everything that documented it was destroyed, sometimes you can go back to the person who sold it to you, and if they don't have any records of it, they can give you a declaration, something along those lines. But if you have anything come up, just let us know. We'll work with you, and we'll make sure we can document.
Okay. And then one last quick question, kind of on that same vein. Is there any circumstance where, with the way that the settlement is being structured and the way that the payout is being calculated, is there any way that the insurance company can come after one of us for additional money or reimbursement of money paid out for insurance?
Yeah, that's a good question. 99% of the time, the answer to that is no. Any insurance company that participated in the subrogation settlement, that is that $11 billion settlement that the insurance companies made, is completely barred. That is their sole right of recovery, and they cannot come after you. There are a very small number, and it may even be less than 1%, but there are a very small number of insurance companies who, for whatever reason, did not file a subrogation claim. For those companies, you have to look at the terms of the policy, and the terms of their policy may be that they have a right to come back and ask you to repay. And for that reason, it's always a good idea just to check and make sure that the insurance company that you have is part of the subrogation settlement. If you have any questions about that, and just so you know, every major insurance company, they're all part of it. But if you have one that's a little bit, more off the beaten path, let us know, we can check. And if it's going to be if it's not part of that, then what we'll do is we'll let the trustee know and say, look, because of that, you can't do any deduction for insurance because his company has a right to come back after him and recover a portion of what was paid. All right, Chewy, what's next?
Yeah, I have, in the past, it says you stated that real property loss, home loss, would be calculated by the insurance, by what the insurance paid, subtracted from what it would cost to rebuild in today's market, which is much higher than other markets. Is this still the way it's going to happen?
Yes. Yeah, insurance company, real property, assuming that you're doing cost of cure, meaning that you want to rebuild and you're doing the cost to rebuild your property. What you do is you come up with the total amount of the damages. So the cost to rebuild your home, the cost to re-landscape, the cost to replace trees, all of that in the current market, then you subtract what insurance paid, and the difference is what your claim amount is.
And what if, related to this, what if you aren't going to rebuild?
Well, if you aren't going to rebuild, then your damage recovery is limited to the diminution in fair market value. So that would be a different analysis. Instead of having rebuild experts, arborists, that kind of thing, we would have an appraiser come out and give us an opinion as to the value of your property the day before the fire versus the day after. The difference is what the measure of damages is, then you subtract the amount insurance paid. Typically, if you don't intend to rebuild and you go the DIV, diminution in value route, you typically recover about 50% less is the general rule of thumb. Can be more, can be less, depending upon your circumstances, but it's usually about 50% less than the cost of cure.
Thank you, Jerry. I do have, it says, are we still able to reach the end of the year for the disbursement of settlement funds? To start the disbursement of settlement funds?
Yes, we believe settlement disbursements will start in September. Now, there's no guarantees, but the effective date, the last effective date in the RSA, the restructuring agreement, is August 29th. So if the trust is funded on or before August 29th, then payments should start in September. Again, there's no guarantees, but that's what we've been working on with the trustee, and he's told us he's committed to getting those payments out. So we're very optimistic payments will start in September, but they definitely should start well before the end of the year. What do we have next, Chewy?
I don't have any more submissions. Everybody, your microphone, you're unable to unmute yourself if you want to ask Mr. Singleton any questions.
All right. Well, if no one has any questions, then just to remind you, next week is going to be the confirmation trial. It'll start Wednesday. Thursday, let's have this town hall meeting again, and I can bring you up to speed on where we are. But the best thing you can do right now is just, if you haven't given us your completed list, or if there's any damages that you haven't given us information on, please do that as soon as you can. We want to get everybody submitted as soon as possible. Thank you for tuning in, and have a great week. I'll see you all next week. Take care.
Jerry,
Thank you, Jerry.
one more question was just submitted via email, if you don't mind.
Oh yeah, please, go ahead.
When you calculate the value of our personal property based on the inventory we submit, do you use replacement value or depreciated value?
It's actually neither. Depreciated value is what most insurance policies use. Some of the more expensive ones use replacement value. The legal standard is unfortunately fair market value, which tends to be less than depreciated value, with the exception of collectibles. Obviously, they appreciate. But for your average household item, unfortunately, fair market value tends to be quite a bit lower. And that's why those numbers, unfortunately, I'm not a fan of the way personal property law works in California, but it is unfortunately very clear in terms of the jury instructions in the case law. So it's fair market value.
Thank you.
Okay. All right. Take care, everybody. Bye-bye.